John Culver was my mentor and hero, and you know, when I worked for him and knew him, he'd been in Congress, so you know, I really was sort of thinking I'd like to someday be in Congress, and then the AG's office became a possibility. That Richard Turner was seemed to be, at least a little bit vulnerable in 73 and 74. It looked like at the time that John Culver would run for re-election in Congress, and Harold Hughes would run for re-election to U.S. Senate, and all of a sudden Hughes decided not to run, and Culver decided to run, and I was planning to run for Attorney General, that was an opening. So John runs for the Senate, and one of my best friends, Mike Doohan, was positioned to run for Congress, so he runs for Congress, and I stick with AG, and I'm sure glad I did that. It's just an incredible office. Three sort of big cases do stand out. One is the tobacco case. Another is the antitrust case against Microsoft, and the third is the bank mortgage cases against the large banks in America. Another thing that stands out is the staff that I've worked with. I've had the chance to work with just absolutely incredible people, and quite a few of them over a period of years that are bright, that are able, that have integrity, that work in the public interest, care about people, care about using the law to serve ordinary Iowans. We're not done, we're getting closer, but that's an extraordinarily important case. The harm, the damage to Iowans and Americans through the use of opioids is just hard to believe, and hard to understand that the companies, particularly Purdue Pharma, would engage in what they engaged in. And we have the outlines of I think a really good solution that will help people. We're very proud of what we've done in the criminal law area, and in three major areas. One is handling all the appeals from the county attorney's offices in the 99 counties to the Supreme Court and the Court of Appeals, as many as 500 or 600 a year, to protect the guilty verdicts and the guilty pleas, to play a role in the formation of Iowa criminal law. And then, of course, we have some great prosecutors in our area prosecution unit. Iowa has 99 counties, and some of the counties, as many as half of them, may go 10, 15, 20, 25 years without a murder. Then they all of a sudden have a murder. What do? Well, typically they would call in and work with our area prosecutors, who do a lot of murder cases, a lot of sexual abuse cases, and other cases with the county attorneys. And then we have our Crime Victims Assistance Division that does, I think, great work for victims. So, we're very proud of what we do in the criminal law area, and think that serves the interest of ordinary Iowans as well. Things have changed over that period of time. Society has changed significantly, including and especially technology emergence. But the basic fundamentals and the basic principles that we follow, I think are very similar. We, have done a lot of murder cases, a lot of sexual abuse cases through area prosecution over a period of time, and those are very important to the state, important to the public. The public's attitude towards crime has changed, I think, recently to some extent in viewing sentencing reform. That we went through a period of time, particularly in the drug area, that we thought that if we just locked people up for a long time and had long sentences, that would solve the problem, or go a long ways to solve the problem. I think we found out that that's not entirely true. That addiction is something that drives people in a way that larger sentences, does not deter them particularly well. So embracing the concept of sentencing reform, I think, is both fair and, in long term, I think protects the public as well, or perhaps better, because we're getting more into treatment as a remedy, where we take people away from addiction and away from the crimes that are caused by addiction. That was just an absolutely incredible experience. I mean, that's sort of the lawyer's dream, to argue a case before the U.S. Supreme Court, and it was very daunting. I remember thinking, as I was traveling from the hotel to the Supreme Court building, that here I am. I've been for a few months now, trying to learn the issues that will be argued before the court. And here's a court that was at a time when the 9 had been on for a long time. There hadn't been a change. And I was thinking of these 9 people that they've been on the court for a long time, that they have a relatively small number of cases before them, 80. The subject matters, are pretty confined, that they've written a lot of the major decisions in this area. I was thinking about how much more they knew than I knew. Here I was going to go argue in front of them, but it was a great experience. It goes very fast. One of the great advocates before the Supreme Court, argued 40 to 50 cases, told me that when he prepared for a case, he kept thinking, why am I doing this? There's just so much I need to know. And then he said when he got done arguing it, he would think, when can I do it again? I didn't have quite that experience, but a little bit like it. It was a great experience. It limits the ability of voters to choose who they want to be attorney general, congressman, congresswoman, state rep. That it places a limit on the public's choice, which is not a good thing. And also, particularly in the legislative context, by having term limits, it gives enormous power to the lobbyist, which I don't think is a healthy thing. But obviously I'm biased that term limits would not have allowed me to do what I wanted to do. That when I was out of office in the early 90s, David Ullman was and still is a good friend of mine, and we kept trying to figure out something we could do across party lines to some cause or some activity, and we came up with a few ideas, one of which he mentioned was term limits. And I thought, David, I don't think I'm with you if you're for term limits. The question of my successors was fundamental to me, that I didn't want the office to be limited in the kind of cases that could be brought over the long term. That the powers and duties of this office are very important to me. So the main reason I compromised was that it wouldn't be put in the statute that when Governor Reynolds and I would leave office, then the agreement would go away, that it was an agreement between the two of us. So that was my main objective in dealing with the legislature. That objective was met, and also on a day-to-day basis in terms of the legal business of this state. The governor's office and our office has really had a good relationship for a long time, including now. And so I knew that, and that continues to be the case. There's been some limitations on what I can do, but that's the nature of a compromise. You don't get everything you want, but I got what was most important to me, and also, as I said, that generally the relationship on these issues between us and the governor's office has been a good thing, which I think is important. It's healthy. That I continue to believe that when elections are over, people should work together in the interest of the state, and that's particularly true in interpreting the law. A number of cases involving the federal government we would have been involved in, but we're not. But as I said, that's part of the compromise, and also, I have 23 other Democratic colleagues that are able to do those cases and do them well. So my not being involved doesn't mean that it's not being done and not being done. We decided a long time ago that we were going to try and do what we believed was the right thing. on policy issues, but especially on interpreting the law, to interpret the law as we think a court would interpret the law. And we've done that for 37 years. And occasionally we've had some disputes, including the one with Governor Branstad and then Governor Reynolds on the Lieutenant Governor's position. But that's what we believe the law was. We believe that the court would have ruled that way. Understood sort of, particularly the frustration of the Lieutenant Governor Reynolds, who became governor, and that was sort of one of the first issues before her. But we stuck with what we believed was right on interpreting the law.